Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is how to get the bonding company to pay. So without further ado, I would love to introduce the fabulous William Porter.
Wow, Jesse, that was so nice. Thank you very much. I forget fabulous, guru, wonderful. I'm going to have to hang on to that tape and play it for my wife. Maybe it'll help something. Anyway, thank you for that. Yeah, I'm going to talk to you all about how to get the bond company to pay. The main thing that you need to know is that there's deadlines, and the bond company is waiting for you to fail to meet a deadline so that they can say, we're not going to pay you. So we're going to talk about all that. So without further ado, look here. If you have any questions, you go to webinar chat box on the right, and we'll see if we can get you taken care of. I hope everybody can hear me. It says muted, but I think that's Jesse. So I'm going to continue.
Yeah, we can hear you perfect. You're good.
Very good. Thanks. There's a little legal disclaimer. The rules that I'm going to talk about today are very broad rules, and there are always little exceptions to these rules, and I want to give you the basic rules that if you follow them, it'll take care of almost all the situations that you would encounter on these issues, but they are very important, but they're broad. As always in law, there's lots of little tiny legal rules, and if you think maybe there's an exception to one of the big rules that might benefit you, and in any event, when you get into these things, it's best to talk to your attorney, and it's best to use an attorney who does construction law in one way or another, because it's a very unique and complex area. So here's our agenda for today. We're going to talk about the kind of bonds we're going to discuss. We're going to talk about the prerequisites to a bond claim, and then timing, because you have to do the claim within a certain time and the lawsuit. And there's a particular bond on federal projects. It's called the Miller Act bond. I'm going to talk a little bit about that today, and then some errors and recommendations. Okay, so let's discuss the type of bonds we're going to be dealing with today. The main one that comes up all the time is the payment bond. Let's say you are either a subcontractor or a supplier to a project. This is going to be really important, because if the GC doesn't pay you, then you're going to want to have a source for payment. So I will say this, is that these types of bonds are not always so much available on private projects. They are sometimes, but they're almost always available on public projects. I think the main limitation is that the project has to be for $25,000 or more. Not just your contract, but the entire project has to be like that. And if it is on a public project, then there's going to be a payment bond. And then the other type of bond that we're going to discuss today is the Miller Act bond. So that's only going to be available on federal projects. It's really the only remedy you have on a federal project, except for suing whoever is supposed to be paying you. There's no mechanics liens or stop payment notices or the other type of payment bond we're going to be discussing today, like public and private works in California. None of that's available on the Miller Act, a federal project. So you're going to have to pay attention to that if you ever do federal work. Okay, the prerequisites to a bond claim. So private works, as I noted, they don't usually require a payment bond. You're going to want to look at your contract or subcontract document, because it'll say in there generally if there is one, and public works almost always do require the payment bond. But the main prerequisite on a payment bond claim is the preliminary notice. And this is a document that you have to send out sometime between when you contract for the work and 20 days into the project for yourself, 20 days after you have supplied labor or material to the project. That's your window for getting the preliminary notice served. And do that, and then you've done the main thing, and that'll help you also, of course, with your mechanics liens and stop payment notices, because it's a prerequisite for most of those too. So I might note though that in public works projects, okay, a preliminary notice isn't required for a first tier sub. You know, that's a sub that has a contract with the prime contractor. But second tier subs and suppliers generally must send a preliminary notice as a prerequisite to a payment bond claim on public works. And I threw some statutes in there on this page. and you can look up those statutes. You could just go online and say California Civil Code 9300, for example, and you'll find all that stuff so you could read all about it. All right. Here's more prerequisite. Now, there's something called a payment bond notice. It's a document that gets sent out, but honestly, it's not always required. It is recommended, though, and you can find those. In fact, SunRay probably has all this and can probably do all this for you. And then we have these forms on our website as well, and you know they're available out there. But SunRay is your source, and they can probably take care of the whole thing for you without making any mistakes. Okay, you want to serve your payment bond notice if you're going to after you know the full amount that you're unpaid and the payment is delinquent. So you're not going to be wanting to do it earlier because you have to put in the full amount that you're owed. So you have to get to the point where you're not owed anything further, and then you can send it out. It's a good method of getting the ball rolling. Okay, I would say it's best to serve a payment bond notice at the same time that you're going to be recording a mechanics lien on a private project or serving a stop payment notice on either public or private. But noting again, it's also possible to proceed to the filing of a lawsuit, which includes a payment bond claim without actually having first served a payment bond notice. So sometimes it's optional. Talk to your attorney about it. Anyway, though, it is a recommended step in the process. All right. Okay. Now for federal projects, which is the other type of payment bond that we're going to discuss, the Miller Act payment bond, no preliminary notice is ever required on federal projects. It's just not part of their process. But you might note that on federal projects, if you're going to make a claim on that Miller Act bond, whoever has a contract with a first tier subcontractor, so there's the contractor, there's the first tier subcontractor, and then there's you. If that's you and you have a contract with the first tier sub, you have to serve something called a 90-day notice on the direct contractor no later than 90 days after you as the claimant last furnished work or materials to the project. Okay, so basically you're done, you're unpaid, you've got to get that 90-day notice out there to the direct contractor no later than 90 days after you last furnished work or materials to the project. If you don't do it, you're not going to be able to make a claim on the Miller Act bond. So that's an important prerequisite. All right. The timing of your lawsuit. So all of these things, you know, you do your preliminary notice, you send out your bond claim, maybe your 90-day notice, but then ultimately, if they don't pay you, you have deadlines again for a lawsuit. So it's all these deadlines, 20 days, 90 days, all this. They're very important. If you miss one, the bond company is going to tell you to jump in the lake. All right. So timing of your bond claim lawsuit. All right. So for California public and private bond claims, the lawsuit deadlines are if there's a valid notice of completion on the project, it's going to be your bond claim lawsuit is going to be 30 days plus 6 months from the recording of a valid notice of completion. Now I say a valid notice of completion because generally notices of completion, they're often not valid because they're not within the time periods that are appropriate. A valid notice of completion has to be recorded by the owner generally within 15 days after completion of the project to be valid. So I'll just add, and I put it in other seminars too, that a lot of notices of completion you got are not in this 15-day window, and so they're not valid. So if there's not a valid notice of completion, then your deadline generally will start instead of, let's say for a mechanics lien stop notice or even a bond claim, the earliest of those is going to be a lawsuit deadline, possibly 90 days after completion with no notice of completion. That's going to be deemed to be the completion date. And then you'll have to go from that date. For example, with bond claims, it's going to be 30 days plus 6 months from the completion, which would be measured by 90 days after completion when there's no notice of completion. Anyway, if that seems confusing, feel free to give me a call at my office. And you can see our website, porterlaw.com, and I'll explain it to you. I'll just consider it part of the seminar. Now, if they're like going along with the same deadline, if there's no notice of completion recorded, or if the notice of completion is not valid because it's untimely, then the lawsuit is generally 90 days plus the 6 months from when the project was completed. And then you would file these lawsuits in the California court system, okay? Now, Miller Act is federal project bond, okay? That's different. All the rules are different. The lawsuit has to be filed in federal court. The rule is no later than 1 year after your last work was performed. And note, unlike the California system, with the federal court, it isn't from when the project is completed that your deadline starts. With the Miller Act, it's going to be from completion of your work, not the project completion date. So your work ending triggers the deadline, and you have 1 year to file your lawsuit. And as noted on the bottom of the page here, you would file it not in state court, but in federal district court where the work was performed. Okay, here's a special rule I want you to know on federal projects where there's a Miller Act claim. All right, look at this diagram here. Very important. So let's say you're going to consider working on a federal project. Then you want to go and look at this diagram. And you see the public entity, that's the federal project, the federal government. Then you see the original contractor below that. And then to the right and the left, you see a first tier sub on the left and a material supplier on the right, and then a second tier sub on the left and another material supplier on the right. Then you see a dashed line. You see that dashed line? Now, what you need to do is you need to figure out, where am I in this diagram? I'll tell you why. Of course, the original contractor below the public entity, he can't make a claim on the Miller Act bond because he's the person who had to provide it and supply it and pay for it. So he can't make a claim on his own bond. But all the people below there, until you get to that dashed line, they can make a claim on the Miller Act bond, which is wonderful. However, if you're going to be below that black dotted line, that dashed line, you're not going to be able to make a claim on the Miller Act bond. Under the statute, it just says, no, those people can't. They figure they're too remote, and they're excluded from being able to make a claim. So this is important because, okay, you're on a federal project, you can't do a mechanics lien to get paid, you can't do a stop payment notice to get paid. All you have is this Miller Act claim, and if you're below the dashed line, you can't have it. And then if that's the case, all you would have left is suing whoever owes you the money. Now, what would happen if that party that you're suing goes bankrupt? It happens a lot on federal projects. People start getting into federal projects and they don't know about complying with all the federal requirements, and people get driven out of business. So I have seen many people on federal projects who are below that line, and all they end up getting is a unsecured creditor claim in a bankruptcy. And you know, I'm sure some of you are going, oh yeah, I'm aware of that, because what happens generally is that you get pennies on the dollar several years later. All right, so if you're going to be below that dashed line, consider whether you want to do the project at all, because you can't make a claim on the payment bond, which is a Miller Act bond on a federal project. Okay, just something important to know. All right, common errors. The failure of substance suppliers to serve a preliminary notice on private and public works, that's one. The failure to file a lawsuit within 30 days if there's a valid notice of completion, or 90 days if there's no notice of completion, plus 6 months for the bond claim. But keep in mind, if you're also going to be doing a mechanics lien and stop payment claim, it's an even shorter deadline than that, and you want to do all your claims in one lawsuit. So if you wait for the 30 days plus 6 months, then you're probably going to be too late for the mechanics lien and stop payment notice claim, but you'll be just fine for the bond claim. So you want to get it all done earlier. But this is, since we're talking about bond claims, this is the deadline for the bond claim. Also, common errors: failure of the second tier sub and lower to serve a 90-day notice after last furnishing work or materials on a federal project. And another common error is a failure to file a lawsuit within 1 year after you last finished your work or materials on a federal project. Even if the project's still under construction, you do your claim within 1 year after you last finished your work. Also, let me note this because I didn't before. When I'm talking about you finishing your work in 1 year, that's finishing your contract work. You don't get to include things like when you come back for warranty work and that type of thing, and repairs and all that. It's when you finish your work, excluding the concept of warranty returns, okay? All right, recommendations. If you are the sub or supplier on a California public or private project, always serve a preliminary notice on the required parties sometime after you contract, but not later than 20 days after you start working or delivering materials. Also, on a California project, once you're unpaid, let's say your final payment, please don't let more than 2 weeks or so go by before looking up your lawsuit deadlines, because they could be coming up very quick. So make sure that someone in your office is in charge of that task, all right, and is aware of it. You know, there's many seminars to go to. Also, I've done some for SunRay that talk about all kinds of lawsuit deadlines for the mechanics lien, stop notice, bond claim, you know, and all of that. But if you haven't gone to one of those seminars, you might do that. And I think that sometime in the future, I'm going to be doing a long form seminar for SunRay, maybe 2 hours long, talking about all this stuff. We'll be setting that up in time to come. Okay. When the project ends, your bond claim lawsuit is triggered, and it could be as early as 30 days plus 6 months after the project is completed. So that would be on the California project. But yeah, again, don't forget the mechanics lien ones and the stop payment notice could be earlier. They would be earlier than that, which I note at the bottom of this page. You have these stop notice and mechanics lien remedies, so know those rules and deadlines as well. And then further recommendations. Remember, on the federal projects, your 1 year lawsuit claim deadline starts to run when you finish your work, not when the project ends. And then remember that diagram. If you're below that dashed line, you don't have any right to make a claim on the Miller Act bond. All you can do is sue the people who owe you money. Hopefully they won't file bankruptcy, but it's better to be above the line for sure, and be able to make your claim. Now, a broad rule here at the end of this is follow the deadline rules. As you're going along, negotiate with the bond company as you progress. They're basically waiting for you to make a mistake, and the usual mistake is missing one of these deadlines that I discussed. So don't make that mistake. Okay, let me see what else I have here. We have questions. We even have a little some quiz questions, but I'm going to let Jesse pick it up from there. Jesse, back to you.
Thank you so much, Bill. You really are incredible. I really appreciate all the information. Yeah, so there is a question that has come through, and it says, if a bond isn't recorded, does it extend any of your lien or bond claim deadlines?
Yeah, I could find some case law on that, but generally the unrecorded bond, there is authority out there to say that instead of following, you know, they generally should be recorded, okay? And then all the deadlines I discussed, the 30 days plus 6 months and all that would apply. But there is some case authority out there that says that you could bring a claim on an unrecorded payment bond within 4 years. That would be your contract, written contract statute of limitations is 4 years. And there is authority out there to say that it could be up to 4 years later on an unrecorded payment bond. That is correct. But I would say that the question doesn't come up all that much in the usual course of events because it's so far out there. And I suspect that if I really push that issue, I might get some fight from some other attorney out there. And also there's this. When these issues come up as a practical thing, you end up going to some superior court judge, which is you know, the lowest level of the California court system. Not to say that, no, you know, I don't mean anything negative towards those, but it's not the Court of Appeal, it's not the Supreme Court, the state Supreme Court, or anything like that. And sometimes they get it wrong, and I've had people get it wrong. And then, you know, you operating in a gray area, you don't want to have some judge make a decision, and it's happened many times, and you go, dang, that judge is just wrong. And then you say, well, I'm going to take this to the Court of Appeals. And then it's like, oh, wow, that's going to cost my client like, 25, 30 grand, whatever, to go to the Court of Appeals. So, there's the practical things. So try not to operate in the gray. Try to get your claims done as soon as you can, and then you won't run into problems that arise when people delay making their claims and filing their lawsuits. Okay, I wouldn't wait the 4 years, is what I'm saying.
Okay, yeah, for
Okay.
sure. All right, well, thank you so much for that. Another question that has come through, it says if a bond, if on a large commercial job, and you are aware that there's a bond, but you don't have a copy of it, can you request the bond from that private job from the GC? Are they required to provide it to you?
I think that they are. I don't have the statute in mind, but I think that is the case, and that is often a problem. See, the GC, and you could go to the owner too, probably, unless there's a contract clause that says that you can't. It's usually in some type of bid package. But yeah, I would make a claim directly to the GC, and if that doesn't work, you may want to go to the owner, because the bond is to protect the owner. So the owner is likely to say, yeah, here's the bond info. I don't want to lien on my property. I would rather have you go after the bond company. Also, the GC may hesitate in giving you the information, because as between the GC and the bond company, the GC has generally agreed to defend and indemnify the bond company if you make a claim on it. So you making a claim against the bond company is almost like you making a claim against the GC, because if the bond company pays, they're going to go against the GC to get reimbursed. And the GC probably had to post some security, like, I don't know what it might be, a bunch of money, a vacation home, their accounts receivable, everything that they have. And so a lot of times GCs don't like to give out that information, but I think there may be a statute requiring it in the civil code. I just don't recall the number of the statute.
Okay. Another question that has come through, if the contractor has a valid reason for not paying the supplier, such as they themselves have not been paid, would a bond company ever pay a supplier out on that, or would they want the contractor to be paid before looking into the claim from the supplier?
If the excuse is that the party paying, like a GC paying a sub, hasn't gotten paid themselves, that's not going to be an excuse for the bond company. The bond company is still going to have to pay, and they're not going to wait for all those other things to occur. But I will say this with bond companies, they do often wait for you to file a lawsuit, because that is the last of the deadlines that you can miss. And once you file the lawsuit, then things get resolved, and the bond company often goes to the GC and says, hey, we're obliged to pay on this. I'm sorry that you have not been paid, but there's a bond, these people need to be paid, so we're going to pay them, and we're going to come against you to reimburse us, because this is our obligation as a bond company. So,
right.
There's my thoughts on that.
Okay, well, thank you so much. I do believe that that's all the questions that have come in so far. If anyone does have another question that wasn't addressed, please feel free to reach out, and we'll be sure to answer any questions as soon as possible for you. Can you go to the next slide for me, please?
Oh, pop quiz.
All right. So who is ready to win a gift? We are testing your knowledge. If you can answer these questions correctly in the chat, we'll go ahead and send you guys a little gift, a little prize from us. So take a look at these questions, see what you know. If you know those answers, get them into the chat for us, so we can get you out that little surprise, a little gift for you guys. All right, and then
Should I give a little clue, Jesse?
Yeah, go ahead.
Okay.
I think we've given them sufficient time.
They are like ABC, or maybe it's BC, or maybe it's CDA. They're all in a row. Anyway, if you get one for sure, you'll get the others. Whoever can type the quickest. Okay, I'll move to the next.
Yep, exactly. All right, thanks so much, Bill.
Did I move? Okay, ready? Here we go.
Yep. All right. For this slide, if you guys want, go ahead and scan that QR code. Here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. So we have the deadline calculator, we have project information sheets, the state lien laws. So if you're working in another state, remember each state has its own set of lien laws, the rules, the deadlines, what types of documents are necessary. So please check that out so you guys can keep yourselves protected and know what you've got to do. All right, next slide if you don't mind. All right, so our next webinar with Bill is going to be don't sign a release unless it says this one thing. That's going to be Thursday, November 14th at 10 a.m. Pacific time. So please go ahead and sign up for free at sunraynotice.com/education. We hope to see you guys there for that. And then the next slide, if you don't mind. All right, if you guys don't mind, take a moment to scan that QR code, give us the feedback on this webinar. We really appreciate any of the feedback that you can give to us. It helps us make sure that we're addressing any future topics that you guys want to learn about and hear about, and get the information straight from the attorney and a reliable source. So we appreciate that. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Again, thank you so much, Bill. You really are incredible. We hope you all have a wonderful and beautiful sunny day. Thanks again,
Thanks,
everyone.
Jesse.
Bye-bye.
Thanks, everyone. Bye-bye.